Welcome back to Law and Crime. I'm Judge Ashley Wilcott. Happy to be with you this afternoon. Thank you for joining us. We're going to continue coverage of a couple of different things today, so I want to give us a rundown of where we are. The first thing I want to mention is that we are continuing to monitor the Jason Carter case. Now, this is the case that we have been discussing about covering out of Ohio. He is accused of shooting and killing his mother. His father had filed a civil lawsuit against him for wrongful death. The father won that. The jury awarded $10 million to the estate of the victim, his mother. He was then arrested 2 days later, 3 days later, he was charged with this crime. Now, they were in jury selection in that trial due to weather. That has been postponed today, so they are not in jury selection today. They expect jury selection to continue in that case tomorrow. We will continue to cover that case here on Law and Crime. Now, R. Kelly, you may have heard the news, has been arrested on child support. He is currently in jail. We're going to be discussing that later on this afternoon as well. The next thing I want to talk about is the live trial that Law and Crime has been covering here first, gavel to gavel, Florida versus Nouman Raja. Now, this is the case in which the ex-police officer was charged with different crimes for shooting and killing a victim, 31-year-old Corey Jones. Corey Jones was a stranded motorist at the time on the side of the road. It happened in the wee hours of the morning, and a verdict is back. First, before we go to that, let's have a recap to learn more about what happened in this trial.
Reggae drummer Corey Jones was driving home at 3 in the morning when his car broke down on a Florida interstate. He pulled off to the side of an exit ramp. Shortly later, police officer Nouman Raja pulled up in front of him. In this police video, less than 5 hours after the incident, Raja tells his side of the story, still dressed in the clothes he was wearing when he pulled the trigger.
I said, "Hey man, police, can I help you?" The second I said police, he jumped back, and I clearly remember him drawing and pointing a gun at me. I saw that silver muzzle, and he had, I can swear on this, he had a Laser Max laser in the guide rod in the gun, and I saw that red light of that Laser Max flashing at me.
But Jones was on the phone with roadside assistance. Nowhere in the recorded call does Raja identify himself as a police officer.
Stop. I'm good. I'm good. Yeah. Get your fucking hands up. Get your fucking hands up. Go.
Oh my God.
Prosecutors are basically accusing Raja of lying, not just about identifying himself, but also about the laser sight he claims was on the victim's gun.
Did that appear to be a Laser Max laser to you?
It did not appear to be. That gun has an enclosed guide rod anyway. That gun wouldn't be compatible with the Laser Max laser.
Even fellow officers questioned Raja's tactics.
Is it paramount to the safety of the officer to make sure that they are clearly identifiable to a person that they're conducting a traffic stop on?
Yes.
Raja was driving an unmarked van. Prosecutors say there's no way Jones would have known he was a cop.
He's wearing jeans. He's wearing an inside-out T-shirt, a hat, no badge, nothing. That's not how an officer talks to a citizen if they're talking to one on the side of the road. He's actually chasing Corey Jones away from his vehicle.
Raja argues the shooting was in self-defense, since he claims Jones pulled a gun on him, which Jones usually kept in the glove compartment. For the Law and Crime Network, I'm Aaron Keller.
Thanks to Aaron for that. Now listen, so the jury had a really difficult decision in this case in terms of the prosecution versus defense theory of the case. Prosecution said in the opening statement, with great power comes great responsibility, and alleged in the theory of the case was, listen, this man's acts amounted to criminal acts that resulted in the death of this innocent victim. Now the defense stood up in their opening argument and said, nope, it was just the stress of the incident and it was reasonable in these circumstances. And it was acceptable. It was not actually murder. So this morning, breaking news, we have a verdict in this case. Let's listen now to the verdict in Nouman Raja's case out of Florida.
State of Florida, plaintiff versus Nouman Khan Raja, defendant, verdict. We, the jury, find as follows. As to count one, we find a defendant guilty of manslaughter while armed with a firearm as charged in the information. As to count two, we found a defendant guilty of attempted first-degree murder as charged in the information. If you find a defendant guilty of attempted first-degree murder, you must next answer the following questions. Did the state prove beyond a reasonable doubt that the defendant actually possessed a firearm? Yes. Did the state prove beyond a reasonable doubt that the defendant actually discharged a firearm? Yes. Did the state prove beyond a reasonable doubt that the defendant, in discharging the firearm, actually caused great bodily harm or death to Corey L. Jones? Yes. So say we all, the 7th day of March, 2019, in West Palm Beach County, Florida, signed, jury, foreperson.
Poll the jury.
Juror number 1, were the verdicts is read your verdict? Juror number 2, were the verdicts is read your verdicts?
Yes.
Juror number 3, were the verdicts is read your verdicts?
Yes.
Juror number 4, were the verdicts is read your verdicts?
Yes.
Juror number 5, were the verdicts is read your verdicts?
Yes.
Juror number 6, were the verdicts is read your verdicts?
Yes.
Well, there we have it. The jury found beyond a reasonable doubt that he committed all of these crimes. I want to bring in my special guest, legal analyst here with us today, Matthew Mangino. Thank you for joining me.
Thanks for having me.
So let's talk about this verdict. First of all, we know there are only 6 jurors in this case that made this decision. And tell me, is it typical that when a jury, when the findings of the jury are read, that they go through each element and say, yes, we found this beyond a reasonable doubt. Yes, we found this beyond a reasonable doubt. Is that typical in your experience?
Well, it could differ from jurisdiction to jurisdiction. Here we're in Florida, and the verdict in Florida requires, under the attempted first-degree murder statute, that the jury specifically say that they found beyond a reasonable doubt each of the elements of that offense, which is what you heard from the court clerk there, who read the verdict off as it was presented to the court.
And then I did see that the jury was polled at the end, and that just means that obviously they ask each individual juror, is this your finding? Did you find guilty? Is that typical, or is that something that defense has to request?
Well, typically, the defense would request a jury to be polled, and it's not unusual, certainly in a serious case, to ask the jury to be polled. And it may be surprising to some, but there are certainly situations where a juror stands up and says, no, that isn't what I agreed to. You know, maybe they were feeling the pressure in the jury room. Maybe they were unsure about their decision right at the last moment. So it's important that that's done so that each juror specifically says, yes, that is my verdict.
All right, so talk to me a little bit, Matthew, about, first of all, the jury deliberated approximately 4.5 hours yesterday, is my understanding. They did ask to see some of the evidence again, and there were 3 different things they wanted to see. One was the audio, of all the 3 things. It was the CSI video, the crimes. Wait, let me back up. There was the video, the CSI crime scene video, which included the defendant's body. They wanted to hear again the audio of all 3 things, which included the dispatch call, the 911 call, and the roadside assistance. And then the third thing they wanted to see, make sure I get this right, was the video of the defendant's reenactment. So why do you think that they wanted to see all 3 of those pieces of evidence again as they were deliberating?
Well, during the course of a trial, obviously there are issues that come up that you have an opportunity to give some thought to or reflect on just for a brief period of time, because the trial's going on. And, this may just have been a case of, hey, let's make sure that what we thought we heard in the courtroom, we actually heard, and that our recollection is accurate. And what I think that shows is a jury who is very diligent, a jury that wants to make sure they get it right, a jury that understands their civic duty to sit in judgment of a fellow citizen. So I think it's really a sign that this jury was doing a thorough job, and they were taking their job very seriously.
And, as a judge, I believe in our criminal justice system, and I find that juries are very sophisticated, and I do believe that justice is served with our jury system. Having said that, have you observed or seen any cases where perhaps a jury deliberates, they might have a decision, but they say, let's go home, we'll sleep on it, we'll take a vote again in the morning? Because I wonder if that's what happened in this case, given the verdict came back this morning.
Well, Judge, we can never get into the minds of jurors. I mean, things that we think are significantly important in a trial, the jury just kind of, goes roughshod over. And then there's other issues that we think are unimportant that they hang their decision on. you know, who knows what the reason is? You know, I often said when I tried cases that you know, juries want to hold out for lunch or hold out for dinner before they make a decision. They figure, what the heck, we might as well get dinner here. Well, in this case, maybe they did want to just take some time to reflect on a good night's sleep and come in the morning and make sure they were making the right decision as they understood it.
All right. Well, Matthew, stay with us for some more of your great analysis of the trials we're covering today. Right now, what I do want to do is share with you a statement made by the attorneys for the family of the victim in this case. Again, Corey Jones, 31 years old, played music, was stranded on the side of the road, was not engaged in any illicit activity, was simply stranded waiting with his car. They did issue a sentence after the, a statement after the conviction that I want to read for you here now, first on Law and Crime. For 3 long years since the heart-wrenching and senseless death of Corey Jones, his family and countless others have been waiting for justice. Today, a Palm Beach County jury delivered that justice. This verdict is a vindication of the good man that was Corey Jones and an utter repudiation of a criminal who tried to hide behind a badge. We see what can happen when prosecutors have the dedication to charge an on-duty law enforcement officer in the murder of an innocent black man, and what can happen when a thoughtful judge rejects a shameless ploy to use Florida's questionable stand-your-ground law as a shield against wrongdoing. The jury saw that this disgraced officer killed an innocent man, and it's only right that he now faces the consequences of his horrendous actions. Though the Jones family will miss Corey for the rest of their lives, they can only finally start to heal knowing that justice has finally been served. Again, that's a statement from the attorneys representing the family of Corey Jones, finding that justice has been served. Certainly Corey Jones will not be forgotten and will live in their memories forever. We're going to take a short break. Please come right back at the other side to continue with coverage here on Law and Crime. So again, the prosecution had put together, and I think it was the FBI that did it, different audios occurring at the same time. So what you actually heard in that was, number 1, the victim on the phone with roadside assistance, number 2, dispatch, and number 3, the defendant called 911, which you heard him do, and said, I have one man down, one man down. Now, Matthew, let me bring you back in. Let me ask you this first. Looking back, hindsight 2020, are there any legal grounds that you can think of that defense could have objected to all of these audios being put together versus being required to play them individually?
Well, I'm sure they're going to raise that as an issue, you know, and try to frame it in some way that it was prejudicial to the defendant. But you know, the bottom line is, you know, this is compelling evidence, even though it's all put together on one audio so that the jury can hear it. It's pretty compelling, especially when you match it up with the other evidence in this case, that in fact it was an unmarked vehicle, a van. He was not dressed in a police uniform. He did not yell police. He didn't even have a badge visible. So there's no way that this individual, the victim here, knows in fact that he's being approached by a police officer. All that he sees is a man armed approaching his vehicle.
Well, and it's interesting to compare this to some of the other trials that we covered with police officer shootings. And I feel like in this case, I'm not saying the police weren't in support of a police officer, but I didn't feel as if they were making a really big deal in saying, no, 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 he didn't do anything wrong. He was acting in the course as a police officer. Instead, I almost felt like he was left out there on his own in this case because of some of the things that he'd done, the way he parked his vehicle in front of the victim's car, plain clothes, some of the other things that aren't typical for law enforcement when they respond to a situation. Do you have any sense or opinion on that, and whether or not the police officers supported him throughout the duration or felt like, hey, listen, you did some things maybe you shouldn't have?
Well, these are always difficult cases because, you know, you're being asked as a juror to get into the head of this police officer and make a determination of whether his judgment was reasonable at the time. The thing that's always difficult is that, you know, this is a case being prosecuted by prosecutors are typically, working with police officers. There's other police officers who testify in this case and who are testifying under oath, and they, have to explain, what they perceived or what they understood at the time. And obviously, it looks as though the prosecution and the police are against this individual police officer. But, that's just the situation that exists. Prosecutors prosecute crime. If there's an alleged crime here and we ultimately know that they've proven their case beyond a reasonable doubt, hey, it may look bad, but that's the way it is.
All right. So what I'd like to do next, because the next thing that happened after all the evidence was presented, as we all well know, what happens next? Closing arguments. And so I want to look back at the prosecution's closing argument to see how did they sum up the evidence they presented to convince this jury to find this defendant guilty.
This man had multiple opportunities to make himself known as a police officer. As a matter of fact, when he pulled up and he saw that car door pop open and he realized that it was not abandoned, guess what he could have done? He could have continued to drive on. He could have continued to head where he was going, which was supposed to be to the Lux to assist his fellow officers. When he realized that the car was occupied, he could have continued to move on, but he didn't. So he had every opportunity to avoid what happened, and he didn't. And he needs to be held accountable for that. I don't care if he was a police officer at the time. It's just like any profession, whether it's a lawyer, doctor, when you make wrong decisions, I don't care what you do, when you make wrong decisions, you don't get a pass. What you get is to be held accountable. And that's what we're asking you guys to do here today. Don't give him a pass because he was a law enforcement officer at the time. This is where the reckless behavior is. This is where the course of conduct that he knew or should have known was going to lead to Corey's death. Now, did Corey have a gun? Yeah, he did. He did have a gun. Legally, rightfully, he did. But did he have it pointed at the defendant? And that's the question. Did he ever have that gun pointed at the defendant that would have justified the defendant shooting him? And the answer to that, ladies and gentlemen, is no. By this defendant's own words. When I directed your attention to Corey saying, hold on, the reason why that's so important, as I said before, is because it shows that the defendant is the aggressor. The defendant is the person who is provoking this.
And that's part of the closing by the prosecution, a powerful closing statement to make. Listen, he was the aggressor. He could have avoided this situation. He did not have to stop. He saw the car was occupied. He could have kept going. And because of his reckless behavior, he knew or should have known that his actions could lead to the death of the victim, Corey Jones, which in fact, in this case, it did. Matthew, talk to me about not only her words, but the presentation of her closing and what you think of the way she presented. Was it effective or not? They did find the defendant guilty, but how did you receive her closing?
Well, she was passionate, which I think is important whenever you're in front of a jury, that you believe in your case. And I think she does a very effective job of portraying to the jury that, hey, this is important. And this is a police officer. We expect more from a police officer. And she's almost indignant about it. And I think that that's an effective message. You don't want to soft sell your case to the jury, especially when there's a loss of life. like this, and I think she did a nice job of portraying that to the jury.
And I think it's important to connect with the jury. You know, I always notice when I've got individuals in front of me making closing arguments to myself, to a jury, their hand motions, where they stand, eye contact, all of those things make a difference in terms of your being able to hear and receive the message. Now talk to me about, I know we talked briefly on Run Break about the fact defense argued stand your ground in this case. Obviously, they did not succeed in that argument, but tell us about stand your ground and what that means.
Well, you know, stand your ground has been around in Florida since 2005, and obviously we know a lot about the Florida stand your ground because there have been some really high-profile cases, the Zimmerman case, you know, for one. But with regard to stand your ground, there is no duty to retreat. So if you believe that you have to defend yourself, you don't have to look back to see, is there some way I can get out of here? Is there some way I can retreat? Is there something different I could do? You can use lethal force to defend yourself in the state of Florida. And that's what, you know, Raja, in this case, attempted to do through his counsel, is to say, hey, he pulled a gun. I had to defend myself, and I took appropriate action under the circumstances. And because of stand your ground, you know, I should not be responsible for his death. The court had decided earlier in pretrial that this case wasn't going to be thrown out as a result of stand your ground, but it could still be raised during the course of the trial, which it was, and the jury didn't buy it.
But let me ask you this, Matthew. What is the intent of stand your ground? Because to me, when I hear stand your ground, I don't think of a law enforcement being allowed to stand their ground and defend themselves, because I think they're able to do that in the role as law enforcement. I would think stand your ground is intended to apply to people like homeowners, if they have a home invasion or someone who's assaulted in the street. Is it intended necessarily to actually apply to law enforcement officers?
Well, I don't know that it was intended when this legislation was debated that it would be used by law enforcement officers. I think it was that the focus certainly was private citizens, but it didn't eliminate the possibility of raising it as a defense by a police officer. I mean, the thing that's interesting about stand your ground is, you know, when you talk about homeowners, you know, the castle doctrine, people have always been able to defend themselves in their home without retreating and use lethal force if they have to. What stand your ground did is it took it outside of the home, you know, to a situation where you're in your vehicle, or you're in a parking lot, or you're in a store. You know, so it stand your ground expanded that theory that always existed, that you could your home is your castle and you can defend it.
All right. Thank you, Matthew. We're going to come back to continue to analyze this trial and what led to the guilty verdict that was issued this morning by the jury. We have to take a short break, but please come right back and join us here on the other side on Law and Crime. So part of closing argument by the defense was, listen, he had no time. The defendant in this case had no time to put on his uniform, to put on his vest. But also part of the defense closing was, hey, you know, he was sitting in the car. He saw him in the car. There'd been a lot of car thefts. So, Matt, tell me, to me, those are inconsistent statements to say, you know, the defendant's in the, the victim's in the car, and then he comes up to this. There'd been a lot of thefts, plainclothes detail. He had no time. Why would he necessarily not have time to at least put a vest on? Because it wasn't as if there was anybody running when he pulled up, not according to his own statement.
Well, yeah, I mean, the issue here is identification, I think, more than anything else. I mean, you know, it doesn't matter, other than internal policy, whether a police officer has his vest on or not. That might be a consequence with the department when he gets back. You know, he's plain clothes, certainly. But he can come out of that vehicle with his badge in hand, making it very clear, police, 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 you know, in order to make some inquiry with this individual. I mean, you know, at first, this vehicle pulls over because they think it's a disabled vehicle alongside the road. Then he sees someone sitting in the vehicle. Then he gets out of the vehicle. I mean, the way he blocked the vehicle seems like an aggressive approach to a vehicle that appears to be broken down alongside of the road.
And so tell me, what do you make of defense's closing argument, the piece that we just showed? Effective or not effective, in your opinion?
Well, he has to deal with the evidence that's been presented in the case. And the evidence that's presented in the case is that this white van, unmarked, pulls in front of the victim's vehicle sideways. He gets out of the vehicle without his badge, without his uniform, without a vest on, and without announcing that he's a police officer in what appears to be an aggressive mode. I mean, he's trying to make lemonade out of lemons, but it's tough, and he's in a difficult position.
Yeah, reckless conduct. So would you have had the defendant testify in this case? We all know that he did the reenactment of the scene with law enforcement. They have a video that was shown. Would you have considered having the defendant testify in this case or not?
The only reason I would have considered having the defendant testify in this case is because he is a police officer. So we know that he has more than likely a clean record. There's nothing that's going to be able to be used to impeach him in terms of his veracity or truthfulness. I would assume he's testified in other cases, so he's had experiences that most defendants don't. One of the reasons I never want to put a defendant on is because I don't want to open the door to other damaging issues with regard to a criminal record, or just the inability to testify in a coherent manner. So here, you're dealing with a different type of defendant, and that consideration should be on the table. And I'm sure that it was.
Right. And we know that sentencing has been scheduled in April. Now, do you expect that we will hear from family members of the defendant, Raja, in this case, during the sentencing phase of the trial?
I think most definitely we will. Victim impact information is very important for sentences. Obviously, the judge wants to hear from the victims. We've already heard a message from the victim's family that was put out today. So I anticipate that they're going to want to take an active role in this sentencing. They're going to want to appear there. They're going to want to talk about how this crime has affected their family.
And so the other piece I'd like to know for the sentencing phase is, we know, and it was not allowed to be introduced into evidence at trial, character evidence of this defendant has had disciplinary history and has had issues in the past in criminal history. Is that admissible at the sentencing hearing, or is that a judge's decision at that time?
No, it should be admissible. I mean, certainly, that has an impact on how the court is going to evaluate the sentence in this case. So everything is open and available to the court for purposes of sentencing. I would assume the adult probation office in Florida will do a background. They'll prepare a sentence memorandum for the judge. Obviously, the defense will do the same thing. To present to the court something in writing with some histories and letters of support and things like that. But what was not admissible in trial is certainly now going to be admissible for purposes of sentencing, and the judge is going to want to have as much information as he can before he enters the sentence.
So again, Raja was found guilty on all counts. His sentencing is scheduled for April 26th. We're going to come right back to continue to look at these trials on Law and Crime after a very short break. Please come back.